All rise. The Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. It appears I left my mask out here the last time I was here. Poor Judge Winthrop had to be in chambers with me without a mask on, so I apologize for that. During your argument, you are welcome to take off your masks. You guys appear to be in the same bubble, so that is good. And you guys are 6 feet apart, so I am fine with that. Judge Swan, can you hear us?
I am.
Excellent. This is cause number CV19-0772, Louis Alexis Solorzano versus Jessica Jensen. These proceedings are being video and audio recorded as well as live streamed, so we ask counsel to please identify yourself and your client at the beginning of your argument. As you can see, Chief Justice Swan is appearing virtually to help us adhere to those social distancing parameters. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we have read the briefs. We have discussed this case. We're familiar with the record. Please take that into consideration during your presentation. At this point, counsel, you may proceed.
May it please the court. My name is Stanley David Murray, and I'm the attorney for the appellant, Luis Alexis Solorzano, and he was the petitioner in the lower court proceedings. I would like to reserve 5 minutes of my time for rebuttal. The main issue in this case, and tell me if you heard this one before in your family law appeals, the due process violation that occurred when Judge Whitehead entered his order of child support without live testimony. Now, I understand that a stipulation was made, and it's the position of the opposing party, the appellees, that that stipulation foreclosed any possible change or challenge to the due process argument. We can agree that due process does attach to child support hearings, but the issue here again is whether that was waived by way of that stipulation. We feel this case is a logical extension of Volk versus Brain, which, well, how do I want to say it? I think emphatically stated that you cannot make credibility determinations based on arguments of counsel, avowals, written testimony, or documents. Credibility requires due process, which means a right to be heard in meaningful time in a meaningful manner.
So Mr. Murray, do you think that's just a per se rule of law that even where the parties fully understand that the issue they're asking the court to resolve will turn on a credibility assessment, and knowing that, they still stipulate that the court can resolve that credibility issue based on the record and the documents submitted? That's an ineffective waiver?
No, Your Honor, provided they were fully advised and acknowledged that they were waiving credibility, which did not occur here. I'm not arguing necessarily against you. I'm just trying to understand what the parameters are here. Okay. It seems to me as going into this hearing, the parties were pretty aware of the fact that not only did they disagree about the issue, but that each side was challenging the other side's story in support of their respective positions. Certainly.
So did the judge really need to have a colloquy with them saying, "You're sure you want to do this"?
Yes, because what the parties thought was that the court would listen to the arguments, review the affidavits, and look at the documents to corroborate what was being said in those arguments. For example, there's nothing in this record that shows my client earned $100,000 a year at any time. So my client, in agreeing to this stipulation, thought that the court was going to review the documents, and that's why he presented documents of what a cosmetologist made, the AFIs that showed mother was either paying more than $2,000 to $4,000 worth of monthly expenses, but yet was claiming she was unemployed. Those were the kind of issues of credibility that could have been determined based on the record, but not by the arguments of counsel, which Judge Whitehead, we feel, did in this instance when he attributed $100,000 to my client. And again, waiver has to be, I'm sorry, Your Honor?
I just want to make sure I understand. So your client was aware that this would come down to a credibility issue, but he just thought that determination would be made based on the documents presented?
Right, that there would be some kind of corroboration, some backup to the findings of which party's attribution of income was justified by the record. So what I want to point out.
So if the judge had said, your client's affidavits make more sense than mother's affidavits, we wouldn't be here?
We would not be here, Your Honor, I agree, because there's documented proof in the record. But where the judge has just estimated that the other side wasn't being truthful because of arguments of counsel, that he wasn't producing documents, which, by the way, if you look at the pretrial statement, my client did reveal and disclose his recent AFI for March of 2019, plus 2018 W-2 statements. So he wasn't withholding information, but mother's counsel made that argument, which seemed to be adopted by the court without any kind of rebuttal or indeed live testimony. Waiver has to be clear showing of intent to waive due process. And again, the transcript that was submitted, and I apologize I did not submit a transcript, but I listened to the CD and I didn't think it was necessary because the minute entry summarized what the agreement was. There was no discussion of whether you were waiving a due process right, no discussion of whether the judge was going to rule on credibility. And remember, the parties had appeared before this judge at a settlement conference before, where no issues of credibility were even raised at that time either.
So counsel, had the ruling gone the other way, you would just stipulate that due process was violated and we'd retry it?
If it had gone the other way, I'm sorry.
If they had taken father's over mother's estimation of the dollars,
Yes, with,
you would agree 100% that mother didn't waive credibility determination either?
as long as there was documentation to support that finding. Yes, ma'am. Yeah, and there's also the issue of whether or not a party can waive a due process issue in this kind of situation. We cited to the Harsh Building versus Belak case that says, yes, stipulations should be enforced because they do help speed up the process, but at the same time, the court should grant relief when certain circumstances are met, such as in this case, where conditions have occurred that could not have been anticipated, or where special circumstances exist, rendering it unjust to enforce the stipulation. We feel those conditions occurred here, and especially with the language from Volk versus Brain. The Volk case disfavors stipulations that alleviate due process, if you will. And I'm quoting from the Volk case, it is fundamental to due process that a court provide a forum for witness testimony, and that it refrain from resolving matters of credibility on documents alone. The court need not accept such stipulation, and, I emphasize this part, should never impliedly or expressly force litigants to surrender the right to testify. So it's at that point where we feel this court should have relieved the parties of their stipulation. Whether there was a disagreement as to the terms or what exactly the court could do, Judge Whitehead should have realized that both parties were raising some very difficult issues of credibility that required testimony. And the judge isn't bound by these stipulations. The judge has an obligation to make sure justice is done. And so for that reason, we feel that he should have taken the lead, if you will, and set aside that stipulation so that he could hear more testimony about the attribution that both parties were both seeking for their incomes. Opposing counsel also raises the doctrine of invited error. And the cases that she cites really don't apply to this situation. This is a stipulation regarding procedures rather than a legal or a factual theory. In the cases that she cited in her brief, Schlecht and the Thorne case, dealt with legal theories that the party who proposed or was the proponent of those theories was now seeking to have those theories reversed on appeal. And again, because due process involved here, we don't feel that the doctrine of invited error would apply because it would basically wipe out the Belak and the Volk holdings.
Murray, if the stipulation had been adhered to in your mind, and if Volk had been complied with by Judge Whitehead, let's assume for the sake of argument it was not, What exactly did you see happening pursuant to the stipulation? That's what I'm having a little bit of difficulty understanding. I understand you think your client did not raise or did not waive his due process right, but how was Judge Whitehead to come to a resolution without making some credibility determinations when you've got two completely different points of view shown in documents? That's what I'm a little confused about. Can you explain that?
Because of that conflict, that's when he should have realized that he doesn't have sufficient information before him that would require him to order the parties to testify, to set aside the stipulation.
Okay.
Because I can't believe you over these documents, and I can't believe you over those documents, because you haven't really covered the issue for me. Like the $100,000 attributed to my client, there's nothing in the record to support that. So that's when he should have had either more testimony or more exhibits at least, so that that issue could have been more fully resolved. Same with the daycare expenses, the $500. That came out of nowhere, and again, it wasn't documented, what the taxi service, or whatever you want to call it, but yet the judge gave that too without any kind of backup on that. Going on to the next issue, even if the court feels that the stipulation should be enforced, that stipulation only applies to the testimony that was submitted, but not documentary evidence. And I cited to a memorandum decision, Clark versus Clark, where this distinction was made. When the parties stipulate that the testimony should be presented by avowals of counsel, or in this case also by affidavits of the parties, it doesn't apply to the documentary evidence in regards to the sufficiency of the evidence to support the ruling. So again, I keep repeating this, but there was no documentation to support the $100,000 child support or income attributed to my client that resulted in that child support award of over $800 per month. So we at least can still challenge the sufficiency of the evidence. And again, attributing income is reviewed de novo by this court. So not only is there no evidence here to support that, this court can make its own decision as to whether the $100,000 even existed to support the trial court's finding, and should be reversed because it's not supported. There was no AFI, affidavit of financial information, from father submitted to the court by either party, even though my client had disclosed it and listed it in his pretrial statement. But apparently mother's counsel knew about that. No basis to award mother $500 in transportation costs, but because she included it in her worksheet, the judge adopted it. But yet, for my client, he listed his child care expenses. The judge didn't accept those, even though those were included in his worksheet. And again, there's no reason for mother to remain unemployed, no documentation to support that. So again, we would ask the court set aside the order, if not for the stipulation, at least on the basis of insufficiency of the evidence. Third issue that we raise is the attorney's fee award. Again, because it was based on this inappropriate finding, this lack of due process that resulted in the attribution of over $100,000 in income to my client, the denial of due process resulted in an incorrect finding of financial disparity, which alone should set aside this finding of attorney's fees award. And as far as the reasonableness factors go, again, the judge cited basically from mother's counsel's arguments that he didn't produce any disclosure, when in fact, if you look at Exhibit 11, I believe, Exhibit 10 of mother's memorandum to the court, we're on our 12th or 11th supplemental disclosure statement. So there's been a lot of documentation that's going back and forth. But again, specifically in regards to the pretrial statement, where the parties have to certify that they've exchanged exhibits, there's a listing of father's updated AFI, there's a listing of his 2018 W-2. So the finding of unreasonableness for lack of providing updated AFI or lack of cooperating with discovery is not supported by the record, especially since there was no motion to compel or any sort of effort to force response to the discovery that we don't even know what wasn't responded to. And finally, we're asking for attorney's fees, and I know it might seem kind of bizarre when mother is unemployed, but if you look at the AFIs that were submitted, mother has resources which resulted in a $6,000 loan in the first AFI and then a $42,000 loan in the second AFI. So she's got resources to pay her own attorney's fees, but more importantly, to pay my client's attorney's fees because of unreasonable positions that she had taken in child court. So we're asking that, and the Court of Appeals rather. So we're asking the court to set aside the child support order based on lack of due process, but also because of insufficiency of evidence, vacate the award of attorney's fees for lack of appropriate findings and supported by the record, and award us attorney's fees on appeal. I wasn't checking my time, but if I have time for rebuttal, I'll take it.
Thank you, Mr. Murray. You have 5 minutes, 58 seconds.
Thank you, Your Honor.
Counsel, when you're ready.
Thank you, Your Honor. May it please the court, Christy Rudin for the appellee, Jessica Jensen. I want to start with the $100,000 in income to father. It was father alleged during the case that he had been terminated from his employment. Back about a year prior to his termination, the parties had filed for temporary orders. And in IR 38, which is their joint pretrial statement for the temporary orders, on page 5, father's position was father's income is $100,000 per year. The parties, a couple of days after that, stipulated to the entry of temporary orders. That's in IR 40, where it says the court hereby adopts the parent's worksheet on child support, which is attached here to and incorporated herein as to the finding of gross income, and the finding of gross income for father was $100,000 per year. So there is evidence in the record to support that father had actually himself represented to the court and to mother that prior to being terminated or allegedly terminated from his employment, he made $100,000 per year. He's now trying to say there's no evidence in the record.
I'm going to ask you to stop.
Counsel, can you hear me?
Judge Swan needs to ask you a question. Go ahead.
I don't know if you can hear me okay, but the first question is just, would you agree that the court's decision in this case depended on a credibility determination?
I would absolutely agree. And I would say that
Okay.
the parties were keenly aware of that at the time they agreed that the court would do so without live testimony.
So your position is that the parties can simply stipulate to any form of adjudication they want, really?
For certain matters, certainly. And in terms of, parties can even waive their constitutional rights in terms of the process that they adhere to.
Without question, parties can waive their constitutional rights, but they can't create powers in the court that the court doesn't have. The courts are not staffed by superhumans. How is it that a stipulation like this empowers the court to make a determination that it's just fundamentally incapable of determining without regard to the Constitution? Just practically, how can that work?
Well, I guess what I would say back on that is, why couldn't the court make the credibility determination based on what was provided? The parties fully briefed the matter. Father did not provide the court with an updated AFI. He had not filed his tax returns. I think the court was able to say, based on the information it was provided, even if it was only by affidavit, that I don't have credible evidence as to what your current income is. I'm going to rely on what your income was prior to your termination.
Well, the parties could waive objections to exhibits. That's one thing. But inviting the court to make a credibility determination without the tools that the law requires seems to be an impossible stipulation to me. If the parties stipulated that the court could make a credibility determination based upon the color of the clothing that counsel chose to wear that day, we obviously wouldn't accept that.
Correct.
Right? Even though the parties stipulate to it. So why would we accept something that so clearly flies in the face of not only individual rights to due process, but the fundamental function and role of the court?
Well, Your Honor, and this was to a certain extent addressed in Volk v. Brame, and obviously you authored that opinion, and the court actually said that the parties can proceed without live testimony. You cautioned the parties on that. And it's certainly not something that every practitioner would willingly walk into in terms of stipulating to it, but I don't think the court is wholly without the ability to judge, to determine the parties' incomes based on their affidavits and documents. Certainly the amount of evidence that was presented to it was more limited than would be with a live hearing. The parties waived that. They knowingly waived that.
There's no question that the court can make determinations about income on documents and does so very frequently. But those determinations usually depend on disputed characterizations, legal principles, the availability or unavailability of data, but they don't depend on credibility. And I like to think I'm fairly familiar with the Volk decision. I don't remember anywhere in that decision where the court said parties can stipulate their way out of this and have credibility determinations made by other means. Am I forgetting something? Were you able to hear me?
Yes, Your Honor, and it was on page 469. I'm trying to find the quotation on it, and you had said that the parties should proceed with caution with it when doing so. However, it was. It says the fact that counsel were given some limited opportunity to outline their respective views of the facts did not remedy the problem. The practice of requiring presentation by avowal is no more effective a means of affording due process than deciding a case based on competing stacks of paper. While parties may stipulate to proceed in this manner, the court need not accept such a stipulation and should never expressly or impliedly force litigants to surrender their right to testify. In the Shacknai case, that issue came up as well, and in Shacknai, Judge Winthrop had written that acknowledged that Volk v. Brame did say the parties could stipulate to proceed in that manner. That's exactly what the parties did here. And Your Honor, one of the most important things.
I'm sorry about the latency, but the question really isn't what the parties stipulated to. The question is whether the court can proceed according to the parties' stipulation. The parties could stipulate that the presiding judge shall jump 1,000 feet in the air. It can't happen. And the fact that parties can elect to proceed by avowal doesn't necessarily mean that the court can perform every function they might wish it to by avowal. It's one thing to say, here's how we're going to present you with the information. It's another thing to say, now you have to perform the full range of judicial functions, of fact-finding functions based on this information. You see the distinction I'm getting at?
I do.
One, the party's waiver, and the other relates to the court's capability to live up to that waiver.
Well, and Your Honor, I would argue that the court did have the capability to live up to that waiver. And in terms of credibility, what the parties agreed on, and again, father knew what mother's argument was. Both parties argued credibility in their pretrial statements when they agreed to do this. And the court had received those pretrial statements before the court and the parties discussed this method, and the court clearly believed it had the ability to do this when they were addressing it on the record and proceeding essentially by written avowal. What the court was able to do was look on the face at the information father was providing and see that there was, to the court, insufficient evidence to show that he had been necessarily involuntarily terminated or was making what he was making, or what he was claiming to have made.
So
the court,
in making this avowal, the court may have known all of that going in, but we look at the stipulation and we look at a waiver of due process and we look at both, and we take that all together. When the parties agreed to proceed in this fashion, what did the judge say to the parties about their avowals, about the determination? Was credibility discussed, and was credibility addressed by the judge, and was due process waived?
well, what was discussed is, and on page 10 of the transcript, the court said, when I get the documents and the supporting materials, what I do is I sit down and I look at those documents, review the calculations, review the positions taken by both sides, and then make my decision. So given that the parties had both filed pretrial statements in which mother was alleging that father was essentially hiding his income and should be imputed $100,000. That father was also alleging credibility. Mother's credibility, and was arguing in his pretrial statement that mother was hiding income, that she was voluntarily underemployed, that her AFI expenses supported it. Everyone understood what they would be arguing, and indeed in father's affidavit that he submitted with his documents, he spent 12 of 22 paragraphs talking about these credibility matters. The parties were fully, if father was not aware that credibility was going to be addressed, why did he spend 12 of 22 paragraphs of his affidavit addressing it? Why was most of his legal brief addressing credibility? And to the extent that father claimed that he had no idea that this was going to happen, in his legal brief, he actually brings up what was in mother's pretrial statement and addresses it item by item, and then again goes through his affidavit and spends 12 of those 22 paragraphs talking about defending his credibility and then attacking mother's credibility.
I'm not sure that makes this proceeding look any more sound when you say that.
I'm not understanding your point, Your Honor.
Well, I mean, you're talking. When you describe what father did in this case, you're really describing what both sides did and what is so deeply troubling under Volk. I'm wondering what the upside of this stipulation is. Are the parties that busy they didn't have the 15 minutes to attend the hearing?
Well, and actually, that was one of the things that came. Father is arguing that he didn't have the opportunity to address the items that were brought up by mother in her legal brief, that he didn't have an opportunity to address the disclosure claims and all of that. However, if you go to the transcript, it starts with Ms. Mosier, Your Honor, could you detail what to expect in this brief? The court says, certainly. Do we want to do simultaneous briefs with no responses, or do you want to do responses? Mr. Davis says, I would prefer simultaneous briefs without responses because it's cheaper for the clients. Ms. Mosier says she agrees and says, I think it also gets to a result more quickly. And so father, with his desire to get a result more quickly, waived having the hearing. The parties, I understand where this is not necessarily commonplace, but the parties have the ability, it was addressed in Pearson, to stipulate to a certain method. And at the time the parties stipulated to it, everyone understood exactly what the arguments were going to be made. Father even knew what the child care argument was going to be made because that was addressed in the pretrial statement, and father even addressed the child care argument in his pretrial statement and questioned why mother would have a child care expense.
But Pearson was decided 20 years before Volk, and I don't believe it dealt with credibility.
And I'm sorry, I wasn't able to hear that.
Judge Swan, I have a question when you're done. Please finish your question, and then I'd like to ask one.
And I'm sorry, Judge Campbell, I'm having difficulty hearing you.
Re-ask your question, and then I have one. Can you hear me now?
Okay, yeah, that was much better. Thank you. No, my question got derailed, I think, by our. But my question was about Pearson, which was just, it was decided 20 years before Volk, and Pearson did not authorize the determination of credibility through means other than oral testimony. So I'm struggling to find, apart from a general recognition that stipulations are good in private disputes, struggling to find where Pearson really is the authority for upholding this.
Well, and Judge, if I could pivot that back to Volk v. Brame, which seems to be, I guess, a crux issue here, which is what Volk v. Brame stood for was the right to be able to present the oral testimony regarding credibility. And here, The parties had that right. The court was alleviated, however, of its obligation to hold a hearing. The parties specifically waived their right to have the court take testimony regarding credibility when they entered into that stipulation. And the parties can do that. There's a case that was cited, and I'm not going to pronounce it properly, the Bielak case. And what counsel was saying, based on Bielak, is that the court, once the court realized credibility was at issue, the court should have alleviated the parties from their stipulation. However, the key part of Bielak is may, and it's in the court's discretion as to whether it needed to or not. Stipulations between parties are factual findings. The court clearly felt that it had an ability to determine the parties' incomes based on their written presentations, and that it didn't need the parties to come in to the courtroom in order for the court to make those determinations. In terms of, I want to go back to the issue of credibility as well, and what we actually mean by that, because what the court found was, based on the information father provided, it couldn't rely on that being his actual income, that the reliable information was what he had previously made. The court was able to do that based upon all of the evidence that was submitted, and this wasn't simply legal briefs, it was also affidavits of the parties. And father had not filed tax returns in several years until apparently the eve of trial, had not responded to discovery or requests. The court was easily able to make those determinations based on written documentation. In terms of if I could address mother's income and the child care expense, it's whether it's a transportation expense or a child care expense, it's really the same thing, in that a lot of nannies are going to be transporting children. And mother had raised it in her pretrial statement. Father was aware of it. The court had evidence of that in mother's affidavit, whereas with regard to father's child care expense, it's nowhere within his affidavit. It's nowhere within his documents. The only place that you could find it was on his child support worksheet. The court was able to make the determination that there wasn't sufficient evidence for that. And in terms of mother's income as well, father was asking the court to attribute a higher income to mother. The court went through the evidence, determined mother had not worked as a cosmetologist full-time, had not really worked full-time since 2011. All of the court's findings were supported by the evidence, which was in mother's affidavit. There wasn't a lack of evidence here. In terms of going back...
Counsel, I'm going to stop you there. Are you saying that there was insufficient evidence and that the court did not make a determination based on the credibility of the declarants?
I am saying that the court did not have sufficient evidence of father's current income based on his failure to provide tax returns, W-2s, pay stubs, and all of his bank statement, or the updated bank statements. That, coupled with the fact that father had been evasive on discovery, it was clear to the court that...
But father's affidavit should have cleared that up if it was accepted as true. Would you agree?
If father's affidavit was accepted as... father's affidavit, however, acknowledged that he didn't have those documents.
But he said, I've been let go. I don't have income at this point. Something like this. Yes?
Yes.
Okay. So the court accepted what father said is true and accepted what mother said is true. And you're saying it's insufficient. I'm saying there was evidence in the record that the court could have made a counter-finding to what the court did based on that affidavit. Would you agree?
I would agree. And then
the only issue is the credibility. Who do I believe, mother or father? Would you agree?
I would agree.
Okay. So if we are to affirm, we have to overrule both, correct?
No. No.
Okay. Let me ask you this. Let's say you're here and you're sitting on that side of the table. Same question I asked Mr. Murray. and the court has accepted everything that father has said in his affidavit and accepted every document and decided mother he just doesn't believe. So at that point, wouldn't you be sitting over there making the same argument?
I would not.
Tell me why. That's what I want to hear.
Because the parties stipulated to doing it this way. They took the risk when they did that. Would I have stipulated to a hearing like this, to presenting written briefs and affidavits? No, probably not. That doesn't change the fact that the parties did that. And this is not much different from what happened in CR1, where in CR1, the parties had a dispute over the attorney's fees, and I believe it was Mother's Counsel said, let's submit, during its telephonic status conference, let's submit written briefs. And they both agreed to it, and the court ordered $80,000 in attorney's fees against father, and father appealed, saying he was his right to due process was denied. And Judge Winthrop wrote that father had participated in this process. Father had been a part of that process, and within CR1 stated that Volk allowed for stipulations to proceed that way. I would, if we were sitting here and Judge Whitehead had said, I'm not going to take evidence. You don't get a hearing. This is how we're going to do it. That would be a different story. Absolutely, we'd be in a Volk situation. But in Volk, Mr. Volk was standing up, screaming and hollering, asking for his opportunity to be heard, and Commissioner Brame would not allow anything other than the documents in front of her. Here, the parties stipulated to it. They knew the court was going to address credibility because they both argued it. And they argued it not only in their pretrial statements, but in their briefs.
Okay, counsel, let me ask you this. When we look at, let's take it out of the family law context. Let's move it into the criminal law context. I know the burdens of proof are different, yada, yada, yada. But when we talk about a waiver, waiving a constitutional right, we require certain magic words to be said. We require the judge to go through a certain kind of explanation about, you understand you have the right to this and you're waiving it. Was there any of that discussion? You have a right to due process. You have a right to present live testimony. And did he get a knowing waiver by both parties?
Your Honor, the parties were in the courtroom for their hearing. They knew they had the opportunity to be heard. Judge Whitehead, they took a 6-minute recess where the parties were able to discuss it with their counsel. When they came back from the recess, and I'm on page 5 of the transcript, the court said, what I'm going to do is I'm going to take another break, give them the chance to talk to you about the solution. If you all want to do it that way or not. If you do, that's fine. We'll just set some dates for the documents to be presented to the court. If you don't want to, we'll talk about what we're going to proceed in the alternative. And they took a recess to do that. They came back on the record, and then they specifically discussed what would be submitted.
But the judge never said credibility determinations are made based on several factors, including the presentation of the witness in the courtroom. So I'm going to be deprived of my ability to see your clients testify. I'm going to be deprived of your ability to convince me, basically, in this trial by you submitting written documents. Anything like that said?
Your Honor, there was nothing further in that way said on the record. In terms of what the parties understood would happen, just by their very briefs and what they put in their briefs, they understood the court. They were asking the court to make a credibility determination in their written briefs, in their affidavits, to the extent that the court was not able to take evidence on live testimony regarding credibility. The parties clearly intentionally waived that.
Have you found any case, though, that ever expressly approved this procedure?
Obviously, CR1, though that was an attorney's fees and not a child support case. Pearson.
Well, take it out of family if you want. Any realm of the law. Have you found an Arizona decision saying yes, courts can make credibility determinations without live testimony as long as there's a stipulation?
I have not. I have not found that case. I
That's telling, isn't it? Because if you think about how busy family court is and how many cases do proceed by eval, you would think that this issue might have come up if this were an acceptable practice.
Judge Swan, I'm going to interrupt you. Time has run, counsel. I will give you just last, very short bite at the apple.
Judge, Your Honor, the parties knew what was going on when they stipulated to this. This is a clear case of waiver. It is very clear that this bench isn't comfortable with the fact that a child support case would be heard via written avowal. However, that's what the parties specifically agreed on. The parties and the court knew what the issues were going in when they determined that they would go this way. Yes, the court is allowed to relieve parties of their stipulations. However, it's up to the court. The trial court has that discretion. This court clearly believed it had an ability to weigh this evidence and make a determination. What Father is now doing is the same thing that happened in Shacknai, which is the procedure. It didn't work out for him, and now he's trying to get another bite of the apple.
Thank you, counsel.
Thank you, Your Honor.
All right, you can have extra time if you'd like, Mr. Murray. If you have 5 minutes and 58 seconds, I'll give you an extra 2 minutes if you need it.
Oh, it won't be necessary, Your Honor. Thank you.
Very well. Please proceed.
Again, Stanley David Murray on behalf of the appellant. Regarding the Shacknai case, however you pronounce it, attorney's fees are a different issue when it comes to due process as opposed to child support. You have looked at the rule on determining attorney's fees, and the court has discretion whether or not to grant attorney's fees. But at the same time, the procedure is simply to submit an affidavit, and the other side gets to respond. You're not entitled to a hearing under the rule, and it's only if the judge orders it that you do provide live testimony when it comes to attorney's fees. So I think Shacknai can be distinguished on that basis because it doesn't rise to the same level as a child support hearing. Yes, both parties did raise issues of credibility. That's what attorneys do. That's how they advise their clients to respond to the issues to be presented. But that's the reason why the judge should have set aside the stipulation. There's cases all over the place. Besides Volk, there's Pridgeon, which talks about you can't have a trial by affidavit when it comes to child custody modification. The rule of law is when it comes to credibility, you have to have a hearing, so that stipulation should have been set aside. Regarding dad's income, opposing counsel cited to the temporary orders hearing, and yes, that was when my client was working at Pegasus, but he never worked there for a full year. He only worked there from October 2017 to June 2018. At the time of this trial, or hearing, if you will, he had been laid off. He had been terminated because of some issues about him not being able to report for work. So he never really earned $100,000, and so that finding is not supported by the record. I think that's all I have, unless the court has any questions for me. I just wanted to raise those points.
Judge Swan?
I'm fine, thank you.
Thank you. Judge Winthrop? All right, counsel. We thank you both for your arguments. It's an interesting issue. We will take the matter under advisement and issue a written ruling in due course. Don't forget your masks. And we will take a short recess to get the courtroom set up for our next argument.